Good evening, ladies and gentlemen. Welcome to the International Nuremberg Principals Academy. Welcome to Historic Courtroom 600, and welcome to the Nuremberg Academy Lecture. The Nuremberg Academy Lecture is a lecture series that has been established by the Academy in order to address important issues of international criminal law and to have them presented and being discussed with a single outstanding speaker. This is the third Nuremberg Academy Lecture, and today's topic is the Genocide Convention, and our outstanding speaker, whom I most warmly welcome, is Professor William Schabas. That things are changing at an enormous speed is, of course, nothing new. But when we were planning the Nuremberg Academy Lecture 24 in autumn last year and asked Professor Schabas, as the world's leading expert on the crime of genocide, to deliver today's lecture, we were thinking about an event marking the 75th anniversary of the adoption of this important convention. We did not foresee then the importance of the convention today before the ICJ, where several cases are pending and even one against Germany. And yesterday evening we learned of arrest warrant applications to the International Criminal Court by its chief prosecutor that have been submitted to the pre-trial chamber against 3 Hamas leaders, quite understandably so, given the massacres of October the 7th of last year, maybe a little bit late, as well as against the Prime Minister and the Defense Minister of Israel for being responsible for the humanitarian catastrophe in Gaza. We understand, of course, that criminal law has limits, and we understand that the system of international criminal law is far from being a reliable system which has a preventive effect, as we can see by the arrest warrant against Vladimir Putin the ICC has issued last year, which has not ended the aggression in Ukraine. I'm very honored by so many guests of today's lecture, given the fact that in Erlangen today there is this wonderful beer festival, the so-called Bergkirchweih, which attracts a lot of students and also colleagues. But nevertheless, I'm very grateful that so many are here today. And I might mention, and a warm welcome again to William Schabas, our guest speaker, and a warm welcome to the landlord of this Palace of Justice, the president of the Upper Regional Court, Dr. Thomas Dickert. I also welcome Michael Frieser, member of the German Parliament, Ludwig Spähnle, whom I see who has just arrived, Commissioner for Anti-Semitism and Jewish Life in Bavaria, Mr. Jungheim from the General Consulate of Israel, a warm welcome, and from the Bavarian judiciary, several representatives, and I would like to mention 2, the President of the Regional Court of Munich, Dr. Schubel, and Mr. Ruland, the Deputy General Public Prosecutor of Munich. A warm welcome to Nuremberg. We have also guests from Ukraine here, from the Taras Shevchenko University. A warm welcome to our guests from Ukraine, and also from Friedrich Alexander Universität and the Pact for Ukraine project. I also like to welcome Ms. Kronawitter, the chairperson of the White Rose Foundation in Munich, and Rainer Huhle, chairperson of the Nuremberg Human Rights Center, and also close friends of the Nuremberg Principals Academy. Likewise, Philipp Muska, where is he? Filippo? A warm welcome. He's from the Syracuse Institute, a similar institute as the Nuremberg Principals Academy, of course, much older. 50 years, I understand, and I'm very grateful that you are here today to visit us and to discuss further cooperation today and tomorrow. A warm welcome to all the students, to all the colleagues, and to all interested persons. This evening, we'll now start with 3 welcome remarks. One by State Minister Katja Keul. She has sent us a video recorded welcome remark. She is State Minister in the Foreign Office in Berlin. After that, the present President Thomas Dickert will speak to us. And after that, Nderitu, she is the UN Special Advisor on the Prevention of Genocide, has also sent a welcome remark. So can we please see and hear Katja Keul. Thank you.
Excellencies, esteemed professors and guests, ladies and gentlemen. The Genocide Convention was a true first. The first human rights treaty adopted by the United Nations General Assembly in Paris on November 9, 1948. One would hope that this 75-year-old document, adopted against the backdrop of one of the most horrific crimes in human history, the Shoah, remains but a symbol and an internal warning for the world thereafter with little practical relevance. Yet, as we know all too well, the monumental convention has lost none of its timeliness. For 75 years, we have witnessed too many occasions where the Genocide Convention had to be applied or where justice was required following mass atrocities. Srebrenica, Rwanda, Cambodia, to name but a few of these terrifying massacres. While the international community repeatedly failed to prevent these tragedies from happening, the Genocide Convention did at least provide us with the right words and instruments to follow suit. So, for example, the International Criminal Tribunal for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the extraordinary chambers in the courts of Cambodia, the International Criminal Court, and also the International Court of Justice. They all took up the language, systematics, and legal aims of the Genocide Convention and turned legal obligations and prohibitions into tangible rulings and verdicts. A multitude of judges, prosecutors, lawyers, and scholars has worked hard to help the Genocide Convention become living law. One of them, Professor William Schabas, will deliver the Nuremberg Academy Lecture today. Professor Schabas, your work on the Genocide Convention has helped us better understand its meaning and to improve its application. You will no doubt help us solve the remaining enigmas of the Convention that will be the topic of today's event in Nuremberg. I congratulate you warmly on your tireless work and look forward to you sharing your insights. Ladies and gentlemen, it comes as no surprise that Germany in particular has taken a keen interest in the Genocide Convention and takes the obligation to prevent genocide very seriously. Not only did the Nuremberg trials bear the seed of the Genocide Convention adopted by the UN General Assembly only a few years later, but also and foremost because we consider it a profound responsibility of Germany to never allow such atrocities to happen again. Therefore, we have been and remain committed to supporting the application of the Genocide Convention where it is legally justified. And we also voice our concerns when we are convinced that this is not the case. Germany has intervened twice before the International Court of Justice to provide its interpretation of the Genocide Convention. In the case of Gambia versus Myanmar, we have intervened jointly with 5 of our closest partners. Together, we wish to put the spotlight on the destructive power that gender-based violence can wield on a minority group such as the Rohingya, or on any vulnerable group. The particular situations of these groups must be taken into account when applying the Genocide Convention. At the same time, and in the case that Ukraine has initiated against Russia, we decided to intervene in order to stress that a state such as Ukraine must be able to receive protection from the International Court of Justice when the Genocide Convention is invoked arbitrarily and when false allegations of genocide are used to justify a war of aggression against the very existence of that state. In other words, with our intervention, like many other partners, we sought to uphold the integrity of the Convention. The strong interest that so many states demonstrate in clarifying the exact scope and extent of obligations under the Genocide Convention shows how relevant the Convention remains until today, and how seriously it is being taken by its states parties. In regard to the proceedings initiated by South Africa against Israel, we plan, like several other states, to submit our views on the interpretation of the Genocide Convention. Let me also mention the most recent case Nicaragua has brought against us, in which Nicaragua has alleged that Germany was violating its obligations under the Genocide Convention regarding the situation in Gaza. As I said, we take our international legal obligations very seriously. We made it clear to the court during our hearing in early April that Germany is doing its utmost to prevent the terrible situation in Gaza from deteriorating, and that Germany has very strict rules when it comes to the export of arms. On 30th April, the court decided that the situation was not one which would require the court to order provisional measures against Germany. It did so by a very clear vote of 15-1. We see this as a strong signal that the court puts faith in the German legal system. At the same time, we are fully aware of the obligations of all states under the Genocide Convention, which this court on this occasion reminded us of. Namely, to avoid the risk that such arms might be used to violate the above-mentioned conventions. I'm sure that when Professor Schabas will speak later on about the obligation to prevent genocide, he will also address this aspect. Interstate litigation on the basis of the Genocide Convention has recently increased. This underlines both the importance of the Genocide Convention in interstate relations and the readiness to use international adjudication on this basis. Ladies and gentlemen, let me assure you that Germany remains strongly committed and a firm and loyal supporter of the system of international courts. We believe in the strength of international law and in the strength of international adjudication. We are strongly convinced that in the long term, a sound legal assessment will always prevail, and that justice does not end where power commands it to. Thank you all for your hard work in this realm of public international law, and I wish you excellent discussions in Nuremberg today.
Excellencies, ladies and gentlemen, as the landlord of the Nuremberg Palace of Justice, I would like to welcome you most warmly to this year's Nuremberg Academy Lecture. The International Academy of Nuremberg Principles has once again chosen a highly topical and extremely important subject. This topic touches me personally very much. Philip Sands, a human rights lawyer and professor of international criminal law at the University of London, has been in our courthouse several times. I feel happy and proud that I was able to get to know him personally and exchange ideas with him. He said that for him all roads lead to Nuremberg. Here, he said, the legal concepts of genocide and crimes against humanity were established. The fight against impunity for wars of aggression, war crimes and crimes against humanity in everyday international law practice is based on the criminal offenses that were first applied in the Nuremberg trials. Philip Sands has written a wonderful book in this context by the name of East-West Street. This book has the following background. When Philip Sands was invited to a lecture event at the University of Lemberg, he realized that not only his own family roots laid here, but that the two lawyers who established the criminal offenses of genocide and crimes against humanity were also from Lemberg and, just like Philip Sands, came from Jewish families. They were the famous law professors Hersch Lauterpacht and Raphael Lemkin. Even during the war, the two lawyers had begun to introduce their ideas into the international legal debate. Lauterpacht campaigned for the protection of individuals under international criminal law and established the crimes against humanity as a criminal offense. Lemkin pleaded for the protection of the ethnic group and coined the legal concept of genocide, using the example of the genocide against the Armenians. Only Lauterpacht was initially successful. Crimes against humanity became an official part of the judgments in the Nuremberg trials. Today, however, the concept of genocide developed by Lemkin is also anchored in international criminal law. During his research, Philipp Sens became aware of the strong urge of the two Jewish lawyers from Lemberg to atone for the crimes that had happened to their Jewish relatives. As we can see, there is a direct link from Lemberg to Nuremberg and from Nuremberg to The Hague. Today, Lemberg is called Lviv and belongs to Ukraine. It touches me deeply that even though the essential building blocks of international criminal law have their foundations in that country, it still fell victim to a brutal war of aggression that violates international law. Fortunately, the city of Lviv, located in western Ukraine, has so far been largely spared from hostilities. However, Nuremberg's twin town, Kharkiv, the surrounding parts of the northeastern Ukraine, and many other places are subject to cruel war crimes and crimes against humanity committed against the civilian population. It was a powerful gesture that the International Criminal Court has issued arrest warrants against Russian President Putin and Russian Commissioner for Children's Rights, Lofa Belova, in connection with the Ukraine war. It shows that Nuremberg was not in vain. It shows that crimes under international law are still considered a breach of civilization today. It shows the will of the international legal community that, in the end, the law must prevail against power and violence. Now I wish you interesting discussions and a fruitful and pleasant stay in this outstanding place in world history, the Courtroom 600. Thank you very much for your attention.
Dear experts and participants at this year's Nuremberg Academy Lecture, I start by thanking the organizers of this important event, and in particular, Professor Dr. Christoph Safferling, who has been a great partner of my office and actively contributed to global discussions on the effective implementation of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. This includes at last 8th December's event, in which we commemorated the 75th anniversary of the adoption of the convention at the United Nations headquarters. So I appreciate the practitioners and academics who are present at the Nuremberg International Principles Academy today, and whose work has remained critical in advancing the implementation of the Genocide Convention. My office, the United Nations Office on Genocide Prevention, was established to support preventive efforts against the recurrence of genocide and related crimes, that's war crimes and crimes against humanity, after the 1994 genocide against the Tutsi in Rwanda and the 1995 Srebrenica genocide. Specifically, I am mandated to monitor and raise alarm over situations across the world where there is a risk of genocide and related crimes. I'm also mandated to raise awareness on the causes and dynamics of these crimes and to strengthen the capacity of member states, regional and international organizations, as well as civil society to prevent them. In 2023, we commemorated the 75th anniversary of the Genocide Convention, adopted in 1948 as the first international human rights treaty ever adopted by the General Assembly. So the theme of the 75th anniversary was, in quotes, A living force in world society, the legacy of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, end of quote. This theme originated from Raphael Lemkin, the lawyer who coined the term genocide and who contributed greatly to the process of drafting the convention. He had hoped that it would indeed become a living force in world society. Implementation requires a multitude of actions by member states, starting with the obligation of not committing genocide. States have the primary and fundamental obligation of preventing genocide, including by not committing this egregious crime. Violating the obligations set forth by the Genocide Convention constitutes not only an inadmissible breach of international law, it also rejects its core values, denying its significance and ultimately failing humanity. In addition to prevention, the Genocide Convention created an obligation to criminalize and hold accountable perpetrators of genocide. And I quote, whether they are constitutionally responsible rulers, public officials, or private individuals, end of quote. As I've said many times, justice and accountability efforts not only serve as a recognition of the suffering of the victims and survivors, but also sets a historical record, playing an important role in preventing future genocides and in curtailing attempts to rewrite history and deny the past. So, dear participants, in its preamble, the Genocide Convention reminds us that at all periods of history, genocide has inflicted great losses on humanity. Genocide is in its essence a crime of identity. The perpetrators are not simply committing ordinary crimes against individuals. They act with a specific intent to destroy, in whole or in part, a national, ethnic, or racial or religious group. They act with the intent to erase an entire group of people, denying their humanity, rejecting their memory and their history, and undermining every fundamental aspect that made them part of that group, their identity. So, what do we need to do? So first is the need to promote the universal ratification of the Genocide Convention and achieve its full legislative implementation, meaning that states need to adopt the necessary legislation at the national level to fulfill their obligations under the convention. The convention entered into force on 12 January 1951, following the 20th ratification or accession by a state party. As of today, 153 states have ratified the Genocide Convention, the latest one being the Republic of Zambia in April 2022. Second is the need to enhance efforts dedicated to early warning and early prevention, including by identifying and addressing the root causes of genocide. We know the warning signs of genocide and other related crimes. We know the risk factors and how to identify them at the early stages when they first appear. Once these early signs are identified, there needs to be early action as part of a comprehensive prevention strategy. Instead of focusing exclusively on responsive action once violence has already emerged, a shift to early warning is key in genocide prevention. Third is the need to support and promote formal and non-formal educational initiatives that promote human rights, respect for diversity, and a culture of peace at all levels and across various sectors of society, schools, universities, public and government institutions, and others. Teaching new generations on past genocides and the processes that led to these crimes equips them with skills to identify early signs and indicators. Education thus contributes to prevention. And in this regard, we have developed together with partners a variety of educational materials and guides on prevention and addressing hate speech through education. Indeed, connected with education and prevention is the fourth recommendation on the need to tackle hate speech, both online and offline, from monitoring global, regional, national, and local trends in hate speech to promoting alternative narratives that counter harmful messages and supporting media literacy initiatives to promote critical thinking. Countering and addressing hate speech in accordance with international human rights law means implementing whole-of-society policies and programs and engaging with various actors. So, for example, my office leads initiatives on promoting the role of sports to counter hate speech, empowering women in communities to address and counter hate speech that could lead to genocide or related crimes, and promoting the role of traditional and religious leaders in doing precisely this. So a fifth set of recommendations refers to the role of international and domestic courts in bringing justice to victims and holding perpetrators accountable, and the need to further support these efforts. Proposals for further action include conducting extensive outreach activities, facilitating access to information, strengthening the role of victims in judicial efforts towards justice and accountability, and preserving and sharing historical records and archives established by these courts. So finally, a sixth cluster of recommendations for advancing the core principles and obligations of the Genocide Convention entails the need to advance concrete action to keeping the memory of the victims alive, honoring their names, and ensuring that their stories are told and placed at the center of every memorialization initiative. So while the primary responsibility to prevent genocide relies upon states, we all have a role to play in advancing these efforts. I therefore encourage you all to reflect on the recommendations I have presented, continue this important discussion to identify further lines of work to fulfill the aspiration of the Genocide Convention as a living force in world society, and find ways within your respective areas of work to take all possible action to prevent genocide. Thank you very much.
Yeah, a warm thank you to both New York and Berlin, and obviously, Thomas, thank you for your welcome remark here in this room. On January 1946, in the morning, Marie-Claude Vaillant-Couttier was called into the witness box by the French prosecutor Dubois here in this room. The witness box was around here, and the prosecutor standing a little bit over there, and the judge's bench before the curtains which were closed. Marie-Claude Vaillant-Couttier, she was a member of the French resistance. She was arrested by French police and deported to Auschwitz by the German occupying power. On the witness stand, she testified on the catastrophic situation in concentration camps, the brutality of the SS, the gas chambers in Auschwitz, the executions in Ravensbrück. There was, however, hardly a cross-examination. And after her excuse from the witness box, Lord Lawrence, the president of the court of the IMT in Nuremberg, said to the prosecutor, quote, "The tribunal thinks that you could deal with the question of treatment in concentration camps rather more generally now, since we have heard the details of the witnesses whom you have already called." End of quote. Of the 218 days in court at the IMT in Nuremberg in 45-46, the Holocaust was only addressed one more time when Rudolf Höss was cross-examined, the former commander of the concentration camp of Auschwitz. The systematic and industrialized killing of Jews by the German Reich was hardly made an issue at the Nuremberg trial. This was one of the reasons why Raphael Lemkin started his campaign for the adoption of a new crime, the crime of genocide. 70 years ago, December 1948, the Convention on the Prevention and Punishment of the Crime of Genocide was adopted and had been rapidly accepted as jus cogens under international law. However, it took until 1998 that an international criminal court convicted an individual for the crime of genocide, which has soon been called as the crime of crimes. The Genocide Convention is nevertheless one of the most successful treaties, however also one of the most contested ones when we look at the current proceedings before the ICJ in The Hague. It is therefore an enormous pleasure to have Professor William Schabas here today as one of the, or let me say, the leading scholar when it comes to the Genocide Convention. He is a real icon of international criminal law. When I started my career and started to understand what the abbreviation ICTY actually stood for, he had already written books on the issue. He's a Canadian. He started his career at the University of Quebec. Since 2000, he has been with the University of Ireland Galway and the director of the Irish Centre for Human Rights. And those worldwide who did not know Galway before, Schabas made it known worldwide in international law, criminal law, and human rights field. He now is a professor both at Middlesex University and Leiden University. He teaches at Sciences Po in Paris, at the Syracuse Institute, and other places. He has appeared as counsel before the ICJ, the European Court of Human Rights, the International Criminal Court, the Inter-American Commission for Human Rights, and he has written commentaries on the International Criminal Court Statute, the Genocide Convention, the European Court of Human Rights. He stood up against the death penalty. He has been a member of the Sierra Leone Truth and Reconciliation Commission. And he has also undertaken historic research, which obviously is most interesting for the International Nuremberg Principles Academy, and here in this room in Nuremberg, with regard to the Genocide Convention, in his book on the Genocide Convention, and also in his recent book on the trial against the Kaiser, a decently researched fictional approach of how a trial against the German Emperor William II could have looked like. The trial was envisaged in the Versailles Treaty, but never materialized. The time was not ripe in 1918 to prosecute a head of state. Is it now? He has countless invitations as guest professor at the most prestigious university in Oxford and Paris. He holds several honorary doctorates. He is a member of Order of Canada and the Royal Irish Academy. It's not the first time he's here in Nuremberg. He's been appearing at several Nuremberg Forum panel discussions. He's been a friend of the Academy since quite some time, actually from the first days onwards. But it's the first time that he's the speaker of the Nuremberg Academy Lecture. He's one of the persons that I certainly feel a bit uneasy talking about international law when he is in the room, because he knows so much more about international law than I do. Please welcome Professor William Schabas. The floor is yours.
Thank you very much, Professor Safferling, Christoph, for such a kind introduction, thorough. I'm very flattered, and above all, I'm very honored to be able to speak here in this hallowed hall, this room where this wonderful historic trial took place. And when you describe the session where Marie-Claude Vaillant-Couturier testified, I can see it still. I've seen the films of it, and I can just visualize her there, how she stood. I think she refused to sit down during her testimony, and she was attacked by the defense lawyer, who suggested that somehow she had fabricated her speech and she had committed it to memory, and she fired back at him with great courage and strength. For those of you who've not seen the clip of her testifying, I strongly recommend it. Distinguished guests, ladies and gentlemen, colleagues, I'm going to talk today about various aspects of this convention. As Professor Safferling mentioned, when we planned the lecture back in October, we could not have foreseen what would ensue in these recent months. And I think these last 4 or 5 months, in terms of international criminal law, have been among the most active and exciting, with cases at the International Court of Justice, hearings, attention devoted to it there, statements by politicians, by heads of state and government, interventions by governments in the various cases at the court, and now, of course, the excitement generated by the announcement that the prosecutor was seeking arrest warrants before the International Criminal Court. Times of perplexity and tumult is how one of the judges at the International Court of Justice, in the recent order in the case between Nicaragua and Germany described our current environment. And I've listed here on the slide the 4 pending cases before the International Court of Justice dealing with the Genocide Convention. These cases are filed often by states and against states that have not generally accepted the jurisdiction of the International Court of Justice, but because they are parties to the Genocide Convention, they have accepted a clause in the Genocide Convention that opens the door to the court. And so these cases have been filed often on the basis, although not entirely so, on the basis of the Genocide Convention. They are also very largely what we call erga omnes cases, a Latin expression that describes the fact that the state that is applying before the court is not itself an injured state at all. It has no particular grievance with the state that it's suing, but it purports to be acting on behalf of the international community as a whole and on the cause of respect for international law in general and the Genocide Convention in particular. And this is all very, very recent. I guess to people who don't do international law, you may wonder why it's so exciting. But for us, this is just an unprecedented time when states are turning to the court in a way that has never before happened. There have been, prior to these 4 cases, I think 14 or 15 cases filed before the International Court of Justice on the basis of the Genocide Convention. Now that might not seem like a lot to you, but bear in mind that all told, since 1946, when the International Court of Justice came into being, there have been fewer than 200 cases. So 15 is a lot, but most of those cases, the vast majority of them, were dismissed at an early stage before they ever got to a full-blown trial and a ruling on the merits. Really only 2 of them, the cases filed with regard to the Balkans, the first by Bosnia and the second by Croatia, led to judgments. And then suddenly, in the last 5 years, we have 4 new cases. The first one, filed by the Gambia versus Myanmar, an erga omnes case. The Gambia has no quarrel, has not been injured in any direct sense by Myanmar, but took it upon itself with the support of the Organization of the Islamic Conference and has filed a case before the court that led to a provisional measures order in 2020, in January of 2020. And we're not too far away from a hearing and a judgment. When I say too far, I'm speaking in terms of the time as the pace of the International Court of Justice, probably 1.5 to 2 years. Then, in February of 2022, Ukraine filed a case against Russia. And this brought on this phenomenal manifestation of interventions by states. 33 of them intervened in the case, 33 of them, and as Minister Keul mentioned, Germany was one of them. All but one of them sent a team of lawyers to the court when there was a hearing on the admissibility of the application. So the International Court of Justice hall, in a manner that is unheard of, was filled with lawyers. I shudder to think what the hourly cost of that courtroom was, with 32 teams of lawyers, plus the lawyers for Ukraine and for Russia, there in the room. And I'm going to have more to say about these cases a little later this evening. And then most recently, the 2 famous cases dealing with the ongoing conflict in Gaza. The case filed by South Africa against Israel at the very end of December of last year, and that has gone through a series of hearings, 2 main hearings on what are called provisional measures, the more recent of them only a few days ago, late last week, and we will be expecting a ruling from the court on that within the next 5 to 10 days, I would expect. And again, we have a number of interventions. And I learned in Minister Keul's presentation that Germany also plans to intervene. And then finally, Nicaragua versus Germany, the case that to date there have been no interventions, but it seems likely that that will happen as well. So taken as a whole, perhaps 50 states out of 193 or 94 states in the world are active as a result of the Genocide Convention, and this is an absolutely extraordinary situation and just underscores the interest of the topic that we so innocently chose last October, thinking that it was going to be more ceremonial than real, but it's very, very real. I want to ask you to indulge me a little bit in a few remarks of a more personal nature, and that may also explain my engagement with this issue and why I became so interested in the subject of genocide. This is a photograph that I took in Rwanda in January of 1993. It's a photograph of a team of human rights activists who were part of a fact-finding mission who excavated a mass grave in a village in northeast Uganda, in northeast Rwanda, I'm sorry. I went there, I had finished my doctorate a few months earlier, and I had been asked to join this group, which was a coalition of non-governmental organizations from different parts of the world. There were 10 of us who went there. We spent 2.5 weeks on the ground in Rwanda, interviewing people, and this very, very dramatic moment when we actually took shovels and picks and dug up a mass grave of Tutsi who had been murdered by the local mayor and some of his cohorts. We later wrote a report that I was very involved in drafting. We issued a press release when we finished our work, and we used the word genocide in the press release. We said that there was genocide was in the air, and I've often looked back to think, how did we reach this conclusion? Because frankly, we knew little about it, and they turned to me because they said, you're the guy with the PhD in international law, you're supposed to know about the Genocide Convention. But I think in those days, our interests were in other issues. We were interested in torture, we were interested in racial discrimination, we were interested in gender equality. It was not at the center of interest of human rights lawyers in the early 1990s. Some of you may have seen an article in the current issue of the New York Review of Books by Aryeh Nair. If not, I recommend it to you. Aryeh Nair was the founder and head of Human Rights Watch. And Aryeh talks in his article about how he had stepped down from Human Rights Watch in '93 and took up another position. And he said, I used the term genocide very, very carefully. I'd really only used it once. And then he said, but in Human Rights Watch, we did decide to call it genocide after I left. And he was talking about 1994. Because in 1993, Human Rights Watch was very nervous about using the word. And we debated this and we quarreled about it. And finally, we toned down the term in our report. I was so, in a way, embarrassed about the fact that I knew so little about the Genocide Convention that I decided to go to the library and go looking for the authorities. And I went to the law libraries in Montreal, where I lived, and looked for the book on the Genocide Convention, only to discover that nobody had written anything of any length on the subject since the 1950s. And so I engaged in a process of studying it. I got a research grant and prepared a book that came out at the end of the decade, at the end of 1999, on the subject of the Genocide Convention. And that book will be republished later this year in an entirely revised edition, taking account of all of the developments in the last 25 years. It's been cited in some of the interventions by states before the International Court of Justice, and it was cited in the hearing in January before the International Court of Justice by counsel for the State of Israel. Well, this is something different. Dr. Dickert, you referred to Lviv and Lemberg and how Raphael Lemkin and Hirsch Lauterpacht and Philippe Sands have ancestors or came from that part of the world, and so do I. My father's family all came from the area just to the east of what they called Lvov, which was Lemberg, I suppose at the time, and then Lviv today. My father, his father immigrated to the United States in the at the beginning of the 20th century. But his parents moved to Germany at the beginning of the 20th century and spent the rest of their lives in Berlin. This is from the family tree because they spelt the name in a slightly different way than I do today. I inherited that from my father. My great-grandparents, my father's grandparents, died in the early 1930s in Berlin. My great-uncles all managed to escape in the late 1930s from Berlin. I think the majority of them went to South America. One of them went to Israel, to Haifa. But my great-aunt, my father's aunt, Hinde Kommel, as she was known by her married name, remained in Berlin throughout the Second World War. And you can see, it's not very clear there, but what the family tree shows, this was prepared by a notary in Berlin after she passed, that she married Kommel, her husband, in 1926, and she remarried him in 1945, in December of 1945. I don't know what happened, why they were married twice, but something definitely happened, and it's clear that her husband, Paul, protected her. He was not Jewish, and he enabled her to survive in Berlin during the Second World War. There were apparently 1,700, maybe a few more Jews who survived throughout the war in Germany. So my connections with my interest in the Genocide Convention has these personal aspects because of my connection both with Rwanda prior to the Great Genocide, but then also because of family connections. I want to show you one last picture. I don't have a picture of Hinde Kommel, but this is a picture of my father in Nuremberg. My father visited his grandparents in Berlin when he was a little boy in the late 1920s. And of course, he returned in 1945, this time in the uniform of an American soldier. And this picture is him sitting atop the parade ground here in Nuremberg in August of 1945. And the other photograph shows, this is a picture that he took of his army buddy, as we would call him, his friend, and you can see behind him the ruined city. This was taken in August of 1945. I doubt he was even aware of all of the excitement going on in this building and in the Grand Hotel and in the Faber Mansion and where all of the preparations were underway, because there were huge teams of American lawyers and professionals and soldiers here in Nuremberg in August preparing for the great trial. And of course, as others have mentioned this evening, the trial was in a way directly connected with the adoption of the Genocide Convention. Lemkin, it's said, was here in Nuremberg when the judgment was issued at the end of September and the beginning of October of 1945, or 46 rather, but I don't think that is true. I think that it's been shown that he was not here. He was in Paris at the American hospital in Neuilly-sur-Seine. And he apparently heard of the judgment or heard part of it being read on the radio there in Paris. And Lemkin then rushed back to New York City, where he campaigned at the first session of the General Assembly. We're talking now late October and early November of 1946 for a resolution on the crime of genocide. Not a convention, that would come later, but he campaigned for a resolution. And this is from the minutes of the Sixth Committee of the General Assembly on the 22nd of November 1946. It apparently is a speech that was written by Raphael Lemkin and given to the Cuban ambassador. and the Cuban ambassador presented this resolution entitled The Crime of Genocide. The resolution was sponsored by 3 delegations, Cuba, India, and Panama, and it says here that he outlined the reasons for which the delegation had submitted this resolution. At the Nuremberg trials, it had not been possible to punish certain cases of genocide because they had been conducted before the beginning of the war. Fearing that such crimes might remain unpunished, owing to the principle of nullum crimen sine lege, the rule against retroactive criminal prosecution, the representative of Cuba asked that genocide be declared an international crime. This was the purpose of the resolution. So the resolution was not exactly a question of endorsing the Nuremberg judgment, but it was a reaction to it. It was to fill a gap, to fill a hole that had been left by the Nuremberg judgment. And what was that? What was he talking about exactly? This is from the Charter of the International Military Tribunal. This was adopted at the end of what we call the London Conference, which took place from late June until early August of 1945, and it was essentially the legal framework for the trial that took place here in this courtroom. The innovative category of crimes against humanity was defined here, namely murder, extermination, etc., before or during the war or persecutions in connection with any crime within the jurisdiction of the tribunal. So it specified that crimes against humanity had to be connected with another crime within the jurisdiction of the tribunal, and those other crimes were crimes against peace, what today we call the waging of aggressive war, and war crimes. And what this provision appeared to create, therefore, was a connection, we call it the nexus, technically, between armed conflict and crimes against humanity. Or put otherwise, there were no crimes against humanity that could be committed in peacetime unless they could be linked to the outbreak of the war. Why was that limitation placed on the notion of crimes against humanity? Why did they do it? Well, this is from the minutes of the London Conference. This is when this is being discussed, and the American prosecutor, Robert Jackson, he was not yet the prosecutor, he was the representative of the United States at the conference, explained the difficulty that the United States had with the definition of crimes against humanity that might be too broad. And he says with great candor, we have some regrettable circumstances at times in our own country in which minorities are unfairly treated. We think it is justifiable that we intervene or attempt to bring retribution to individuals or to states only because the concentration camps and the deportations were in pursuance of a common plan or enterprise of making an unjust or illegal war in which we became involved. We see no other basis on which we are justified in reaching the atrocities which were committed inside Germany, under German law, or even in violation of German law by authorities of the German state. We know what he's talking about. He's talking about the policy of Jim Crow, of lynching, of racial discrimination in the United States. And he's speaking to a captive audience because sitting around the table, it's a small meeting, there are only representatives of the United Kingdom. And what are they thinking about? They're thinking about Nigeria and East Africa and India and all of the places where they too have minorities who are unfairly treated. And the French are there, and the Soviets are there, and they all agree. And they put this limitation on crimes against humanity, the limitation that provokes the genocide resolution in 1946, because of their concerns that if they hold Germany accountable for persecution of the Jews and others in the 1930s, that they too could be held accountable under the same rule of law. And this approach, which could have been rejected by the judges here in the courtroom could have been creative and might have interpreted this in a bolder way, but they were very faithful to the concerns of those who drafted the charter of the tribunal. And this is from the final judgment delivered here on the 30th of September 1946 in this room. And this is one of the references. Professor Safferling referred earlier to the fact that the Holocaust, the Shoah, was not a central theme in the trial, in the evidence, and in the judgment. But here's a discussion of it. The Nazi persecution of Jews in Germany before the war, severe and repressive as it was, cannot compare, however, with the policy pursued during the war in the occupied territories. Originally, the policy was similar. Jews were required to register, to live in ghettos, to wear the star, and so on. What they're saying here is it was bad in Germany in the 1930s, but not that bad, and we're not going to. Nobody was condemned for it. Nobody was convicted for what happened prior to September of 1939. The judges themselves were rather dismissive of the sort of persecution that drove my great-uncles to flee and that my great-aunt inevitably lived with throughout the years during the 1930s and then during the war. This is the convention that's finally adopted. It doesn't refer to a war in Article 2 of the Genocide Convention. It doesn't create a link with armed conflict, and in fact, Article 1 of the Genocide Convention specifies that it can be committed in time of peace as well as in time of war. So it was a huge development in the law, a huge improvement on the law of Nuremberg. But there was a price to pay for this, because the very states who had been so protective of their own circumstances about being held accountable for their own persecution of minorities within their own metropolitan territories, and for states like the United Kingdom and France in their colonies, they weren't going to turn around in 1948 and say, okay, let's fix this. They didn't agree with fixing it, only on the condition that genocide was defined narrowly. And so what we get in the Convention of 1948, people have said this evening already, this was the first human rights treaty, so don't expect anything miraculous in the first human rights treaty. It's the first effort, and it's by states who are very, very anxious, as they still are today, when they adopt human rights treaties, about how accountable they may be for past and current violations. And so the result is what we have in the definition of genocide in the famous Convention of 1948 is a kind of a shrunken version of crimes against humanity. It differs from crimes against humanity in two main respects. The first one is that genocide is limited to 4 categories of group, whereas crimes against humanity can be committed against individuals, but also against groups and peoples based on a range of criteria that we do not find with regard to genocide. In the case of genocide, we have to have a national, ethnical, racial, or religious minority. There's no political minorities. There are no gender minorities. You will find that in crimes against humanity, but as I've explained, the definition of crimes against humanity excluded peacetime violations in 1948. So the agreement was, yes, we will prosecute violations directed against certain groups, but only those listed in the convention, and exclude others. The other facet of this definition that is quite distinct from crimes against humanity is that it requires, and you can see this in the second line, the intent to destroy the group, not to persecute the group. Crimes against humanity only require persecution. It does not require destruction, does not require proof of an intent to destroy. So in 2 important aspects, the definition of genocide is very tightly contained. What do we have then by the end of the 1940s in terms of international law? We have a definition of crimes against humanity endorsed at Nuremberg in the Nuremberg Principles, which are adopted in 1950. They repeat what we find in the Charter of the International Military Tribunal, but they are clear that this is restricted to crimes that have a connection with an armed conflict. And then, of course, we have the Genocide Convention, which covers those violations in time of peace, but it's defined narrowly. And this state of the law is going to continue for the next 45 years, approximately, until in the 1990s, the notion of crimes against humanity is opened up dramatically by such things as the creation of the two international criminal tribunals for Yugoslavia and Rwanda, the adoption of the Rome Statute of the International Criminal Court, and other developments. Let me just say a word or two about what happens in these 40 years between 1950, 48 is when the convention is adopted, 50 is when the Nuremberg principles are finalized. And there's not much in the way of legal development for the next 40 years. One of the main events, and it's an important one, is the trial of Eichmann in Jerusalem in 1961. The courts in Israel apply an Israeli law that is derived from the Genocide Convention, and so in reality it's a trial based on the definition of the crime of genocide. But it's an isolated trial. It's an important one, but it's quite isolated. There are no other trials of that nature that take place for several decades. There's also, and this has been, I think, neglected in a lot of the accounts of the development and the history of international criminal law, there are serious efforts by countries from the South, in particular the new countries from Africa who have become members of the United Nations in the 1960s, to use the concepts of international criminal justice to advance their own grievances: racial discrimination, colonialism, apartheid. And so they campaign, for example, to enlarge the notion of crimes against humanity in order to remove the connection with armed conflict. And some of that appears in resolutions of the General Assembly that they're able to get adopted. They also try to apply the definition of genocide to apartheid. And there were serious efforts within the United Nations in the late 1960s and into the 1970s to use the Genocide Convention and the definition of genocide with regard to the crime of apartheid. And so that keeps alive, in a way, the system of international criminal justice through into the 70s and the 1980s. And then finally, everything comes back to life in the early 1990s. We set up the Yugoslavia Tribunal in May of 1993, the Rwanda Tribunal in November of 1944. The statutes of those tribunals are quite similar legally. There are technical differences, but I'm not going to bore you with that part of it. We have in there the crimes that we inherit from Nuremberg, plus the Genocide Convention. So we have crimes against humanity, war crimes, and genocide. And an amazing thing happens. First of all, in the case law of the international criminal tribunals, the Yugoslavia Tribunal in particular, and then the same philosophy is endorsed when the Rome Statute is adopted, there is an effort to enlarge, but enlarge enormously, the scope of the crimes that we're prosecuting under international criminal law. Crimes against humanity. Crimes against humanity, I've explained the difficulties with prosecuting crimes against humanity, the inability to apply the notion to peacetime, and all of that changes clearly in the beginning of the 1990s. It enlarges the concept of crimes against humanity exponentially. And war crimes. A similar thing happens with war crimes, which were believed up until the beginning of the 1990s to be confined to war crimes in an international armed conflict, a rare event in the second half of the 20th century. And by the 1990s, there's a willingness to enlarge the concept of war crimes to cover non-international armed conflict. So now, we have two legal concepts, the new revised notion of war crimes that applies to war crimes committed in a non-international armed conflict, a civil war, and crimes against humanity committed in peacetime. And what do we do with genocide? We leave it alone. Nothing happens. It's not because the lawmakers are conservative. They've just decided to focus on crimes against humanity and war crimes and enlarge them and leave genocide as a little bit of a monument, as if it was of historic interest rather than of use and of relevance going forward. I remember this at the Rome Conference, where the statute of the International Criminal Court was adopted. I attended that conference from beginning to end in June and July of 1998. And there were these dramatic proposals for crimes against humanity or for war crimes. On a couple of occasions, I remember Cuba put up its hand and said, we'd like to change the definition of genocide to include economic groups. And what they wanted to do was in some way to address the question of sanctions and the embargo on Cuba. And one by one, governments got up, one by one, to say, no, we're not going to do that. Forget it. We're going to leave genocide alone. There's a paper trail of this, of states saying, don't change the definition of genocide. And I believe that spirit continued with judges after the statute of the International Criminal Court was adopted. The judges, not of the Rome Statute, because it's going to be years before they become operational, but the judges at the Yugoslavia Tribunal reflect this desire to leave genocide in its narrow definition inherited from 1948 and to devote their energy to dealing with the atrocities committed in the former Yugoslavia using the terms of war crimes and crimes against humanity. It was a practical decision. Maybe it was a policy decision. Maybe they felt that the word genocide was too provocative or was unclear. It's hard to say why this happened. What I know is that it did happen. It may also, at the Yugoslavia Tribunal, have been the fact that the judges there had a choice between the different categories. So the prosecutor would argue that genocide took place, and the judges would say, it's not entirely clear, but it's certainly crimes against humanity. They had a fallback to say, if it's not genocide, we're still going to convict. It's crimes against humanity. The same way in our national courts, judges do it when we don't have premeditated, planned murder, and we have more negligent or accidental killing, and we have categories, and we can convict people for lesser offenses. That can happen at the international criminal tribunals, and maybe that helps judges to set genocide aside as a category. But it can't happen at the International Court of Justice because the jurisdiction there is based on the Genocide Convention. And if you cannot establish genocide, then you've got nothing. Then the case is thrown out. And that's what will happen with the 4 cases that are pending before the International Court of Justice at present. It's either genocide or largely there are a few distinctions with the case filed by Nicaragua against Germany, but certainly for the 3 of them, it has to be genocide or nothing. The Rwanda Tribunal held a large number of trials dealing with the definition of genocide. These were not particularly difficult or controversial in a legal sense. The case in Rwanda, 800,000 Tutsi murdered in the space of 3 months, the hate propaganda that was so visible, these were not difficult to fit within the terms of the Genocide Convention. And the result is that the case law of the Rwanda Tribunal it was never challenged in the way the Yugoslavia Tribunal was. The Yugoslavia Tribunal was a lot more complicated because at the Yugoslavia Tribunal, we had other notions, in particular the notion of ethnic cleansing. Rwanda, nobody argued that it wasn't genocide, but rather it was ethnic cleansing when they murdered 800,000 people. But in the former Yugoslavia, there were cases where populations were driven out of their territory and where there were questions or doubts about whether the intent was really to destroy the group or simply to displace it. And the result is that most of the genocide charges at the Yugoslavia Tribunal were rejected. Of course, those who were charged were convicted of crimes against humanity and of war crimes. It's not as if they walked free. But the genocide charge was generally rejected for what we call the crimes committed in the municipalities, persecution of minorities, mainly Muslim minorities, also Croatian, and some Serb minorities in various parts of Bosnia and Herzegovina, as well as Croatia. The prosecutor continued to try to get convictions for this until, and the most recent judgment was in May of 2021. So 3 years ago, in the final appeal of the final conviction of General Mladic, he tried one more time and his attempt was rejected. With one exception. At the Yugoslavia Tribunal, the judges did convict for genocide for the massacre in Srebrenica. And so, as has already been done this evening, people speak about the genocides in Rwanda and Srebrenica, but we don't speak about the genocide in Bosnia and Herzegovina or in Croatia. And that has been controversial for many years, but it resulted in judgments this time of the International Court of Justice that echoed the case law of the Yugoslavia Tribunal. The problem, and we're going to see this with these cases at the International Court of Justice, is that it's not really equipped for a complicated criminal trial, where evidence is gathered, where it's tested, where it's presented before the judges, what we expect in a criminal court. But the International Court of Justice, it's not a criminal court. It's a court that deals with state responsibility, and it doesn't have lengthy evidentiary hearings with witnesses who are cross-examined and interpreters and so on. A little bit, yes, but not as a general rule. For the cases from Bosnia and Croatia that came before the Yugoslavia Tribunal, the judges were able to fall back on the work of the Yugoslavia Tribunal. I'm talking about the judges at the International Court of Justice, and basically rely both on the evidentiary findings by the judges of the International Criminal Tribunal for the former Yugoslavia, but also to a large extent on their legal findings. And so, in the Bosnia case, which was decided in February of 2007, the judges of the International Court of Justice rejected the claim that Serbia had committed genocide, concluded that, in agreement with what the Yugoslavia Tribunal had said, the Bosnian Serb forces had committed genocide at Srebrenica, and then made a very innovative finding that Serbia had nevertheless failed to prevent genocide in Bosnia and Herzegovina because of its ability to influence the Bosnian Serbs. Reference was made to that also earlier today, and it's a judgment that was cited in virtually all of the submissions by the states that intervened in the recent case, the genocide case of Ukraine versus Russia. I think, and I've studied those submissions that they all made, including the one by Germany, and I think to some extent they kind of missed the point of what the court decided in 2007. Because what the court did was it really invented a duty of prevention that is hard to find in any detail within the Genocide Convention itself, in two respects. The first respect is that it's an extraterritorial duty. It applies outside your territory. And when the judges at the International Court of Justice adopted this doctrine in 2007, they said, well, there's nothing extraordinary about this. Other conventions, and they cite several of them, impose an obligation to prevent genocide, or to prevent another crime, torture, for example, or terrorism, impose this duty in the convention. Yes, but they don't impose it extraterritorially. There's no convention that imposes an extraterritorial duty on states. And the Genocide Convention doesn't either, at least not explicitly. But the judges devised this. It's a judge-made notion that they applied. And this is relevant, it's important, it's going to be not without relevance in the case between Nicaragua and Germany, for example, where these questions will arise. And the other thing that it was so important in the judgment in 2007 of the court is that this duty to prevent is a unilateral duty. It's not a multilateral duty. It's a duty on an individual state. They weren't saying that Serbia and a lot of other states should have got together and campaigned to try and influence the Bosnian Serbs. They said it was a duty on Serbia standing alone. And that facet and that dimension, as I say, in the submissions in the case of Ukraine versus Russia, seemed to miss all of this. And instead, they just focused on the idea that intervention should come with the approval of the United Nations, perhaps the General Assembly or the Security Council, and it should be multilateral in nature. Of course, what they were trying to do was rule out unilateral intervention, because they were charging, and that was the purpose of the case, was to go after Russia for allegedly claiming that genocide had taken place and using that then as a justification for its military attack on Ukraine. So this is the law that we've inherited from the Yugoslavia Tribunal, from the Rwanda Tribunal, and from the International Court of Justice. And it's a law that approaches the definition of genocide quite strictly. Strict with the definition, strict with regard to the requirement of proof of an intent to destroy the group physically, and a willingness to distinguish it clearly from acts like ethnic cleansing, which resemble genocide in so many respects, but where there may be doubts about whether the intent is to physically destroy the group. And the question now before us, and it's a real one in these cases, is whether that's going to change. Reference was made to the intervention by Germany and 5 other states, Canada, France, the United Kingdom, the Netherlands, and Belgium, Denmark rather, not Belgium, and Denmark, in the Myanmar case. So I mentioned the Gambia versus Myanmar. It's the first of this string of cases. They have now had a round of their main submissions, the 2 parties. They're having a second round, which will be completed this year. Then, in normal times, the court should set a date for an oral hearing. I expect that will happen late in 2025, probably, with a judgment to be issued sometime in 2026. So what the 6 intervening states did was argue that the court should take a more expansive view of genocide than it's done, that it should take a more flexible view of the proof of genocidal intent. They cite a dissenting judge in the Croatia case from 2015 who said that it's become impossible to prove genocidal intent. The court has developed an approach to proof of intent that makes it almost impossible to prove the case. And they say, you've got to be more flexible about proof of intent. This was the dissenting judge, the late Judge Cansaro Trindade. And they said, follow him, follow that path. They also said that you should look for evidence, for example, of population displacement within a territory. This was all with a view to helping the case against Myanmar. We're talking about the Rohingya in Myanmar. And they also emphasized the persecution of children. The fact that children are singled out for attack and persecution, they said, is a further indicator of genocidal intent. It's a very interesting, detailed submission. I don't think that when it was drafted by the lawyers in those 6 states, that they had really anticipated the next case that was in line, which is the case of South Africa versus Israel. Because if, and we're going to see what's going to happen with the Myanmar case in the next 2 years, perhaps, but as that case goes, so will go the case between South Africa and Israel. If they open up the definition in line with the submission by the 6 states, then it's going to be helpful to the Gambia in its case against Myanmar, and helpful to South Africa in its case against Israel. Time will tell how that plays out. But it's in the air. And there's no doubt that there's a growing momentum to change this definition. I think it's also partly a recognition that the Genocide Convention is not an artifact. There was a tendency in the 1990s to treat it that way, a monument, a historical, we use these terms, the legacy of the Genocide Convention, as if it was all said and done, but it was early, it was 1948, it was a conservative definition, now we have better legal tools. But states turn to the Genocide Convention, and we're seeing this. They're interested in it, and they want to see it become more effective. And this is possibly going to be reflected in the judgments of the International Court of Justice in the years to come. So maybe just a word about the other cases. I'll say a word about the Ukraine versus Russia case. It's a bit of an outlier because they're not charging genocide. It's a strange case because it does the opposite. It says that the Russian allegation of genocide is a fake claim, that it's not supported, and that it's being used as was used as a pretext under the name of prevention of genocide. Unfortunately, and this was the decision that was issued at the beginning of February of this year, 4 months ago, on the admissibility of the case, the judges essentially decided to knock out half of it. So they said that the issue of whether Russia was acting in the name of preventing genocide or not, which would have led to the possible condemnation of Russia for the attack on Ukraine, but under the name of a violation of the Genocide Convention, they said, we don't deal with that. That's not what's covered by the Genocide Convention. But they said Ukraine is certainly free to prove, if it wishes, that it did not commit genocide. And Ukraine used, I'm going to check my note because I don't want to misquote it. Ukraine, in its application, had said they wanted the court to conclude that it had committed no acts of genocide. But in its subsequent submission, in its memorial, it changed this slightly to there is no credible evidence of genocide. So what Ukraine is asking the court to declare is that there's no credible evidence. I think this is a bit of an own goal when they've done it, because they're going to court to prove that there's no credible evidence. We don't even know if Russia's going to contest the case. We'll see. They may just decide, say, let them try. Because it's one thing to prove that they haven't met a threshold of beyond a reasonable doubt. But to prove that there's no credible evidence, there's often credible evidence that's not substantial. It's not significant enough for a conviction. It's not significant enough for a finding, but it's evidence. Just doesn't prove it. So I wonder what's going to happen in this case, and I also wonder whether Russia's even going to try and contest it. But that's one of the cases. The other three cases, of course, I've referred to the case with Myanmar, the case with South Africa and Israel, and finally, of course, the new case filed by Nicaragua against Germany. That case is interesting because, of course, Germany's not being charged with genocide, but it's being charged with violations of the Genocide Convention. And so we will, I think, also expect that as that case evolves and plays out, that we're going to see a richer discussion, and I cannot begin to anticipate how it's all going to play out, but this will depend on the evidence, of course, about the notion of complicity. What is it to be an accomplice in genocide? What does it mean for a state to be an accomplice? Possibly also the notion of prevention, but I think complicity is probably closer to the heart of it. And it's one of the problems we also have with the Genocide Convention. It was drafted in 1948, I think pretty clearly with an idea that it was going to be a tool to prosecute individuals, and that the obligations on states were to ensure that the individuals were prosecuted, but it wasn't really, there's some evidence of it in the drafting history, but the whole conception of the convention was not as an instrument to hold states accountable for the violations, but rather to hold individuals accountable and to insist that states had obligations to do this. And so we use terms like complicity that are not really suited to state responsibility. They're well known to us as criminal lawyers. We know exactly what that means. We have little differences. We have some issues between different systems, but it's a familiar notion. Whereas with states, the notion of complicity is more complex and more difficult, and so this issue is going to be assessed. And then finally, as I've mentioned, this question of prevention. And the way things are going, we may have some more cases too. And this is what's extraordinary. Let me just conclude with a thought about the International Court of Justice and international justice more generally. A dear friend of mine, who's now a retired academic, he was a professor of international law throughout his career, told me that when he was finishing his PhD at Cambridge I think in the late 70s or the early 80s, he had this idea. He said, I wanted to go and see a trial at the International Court of Justice. So I went to The Hague, I went to the Peace Palace, knocked on the door, and said, can I see a trial? And the person who greeted him at the trial smiled and said, we haven't had a trial here for 4 years, okay? This was a court that was almost totally dormant. Nobody went there. States didn't trust it. And something has happened in recent years. First of all, the volume of cases has increased. There are now 24 or 25 pending cases before the International Court of Justice. A very significant number of them are human rights cases. We've always had 1 or 2 human rights cases, or with elements of human rights, but we've never had what we see today. We have the 4 genocide cases. We have 2 cases under the Racial Discrimination Convention. We have a case under the Torture Convention. And we have 3 advisory opinions, and this is another type of proceeding before the International Court of Justice. It's a proceeding that requires states to agree. They have to vote in, for example, the General Assembly. So it requires a lot of commitment by states that a question that would ordinarily be settled politically in a negotiation, by a resolution, and so on, we're going to leave it in the hands of 15 judges. I think historically, a lot of politicians and governments were always nervous about this. It's one thing, but they won't always do it even in this case, but it's one thing to say to judges, we have a little quarrel, Germany and France, there's a little piece there in Alsace-Lorraine that we think might belong to us, or there's a little bit of the Rhine River that maybe, let's go and we'll get the judges to decide it. States can do that. But they're asking states to decide on things like, what are the legal obligations of climate change? Is there a right to strike within freedom of association? And so on. And so altogether, it's more than half the caseload of the International Court of Justice. Back when the UN was founded in the 1940s, there was talk about setting up an International Court of Human Rights. Australia proposed it. It never happened. It never happened. And there have been campaigns periodically to set up a permanent International Court of Human Rights. There's no traction for it. Every once in a while, one country gets the idea of promoting it. I think Switzerland did some years ago. And they get a few academics to write papers about it, and there's a little bit of talk, and a few conferences are held, and then they drop it. And it's curious, because we don't have any trouble setting up new courts. Look at the International Criminal Court, a brand new court. States are willing to do that. We have regional courts of human rights. We have the great European Court of Human Rights. It's not as if states are opposed to it, but somehow it just can't click. They can't figure out a way to get this World Court of Human Rights. But I think, in a way, we have it now. It's the International Court of Justice. And they have this huge caseload. They're going to have to make some changes. But what is so remarkable is the willingness of states to go there, to trust the judges, to issue the judgments. 15 judges from different parts of the world with different outlooks, and yet, and we've seen this, they can agree. It's really also an extraordinary phenomenon we've seen in these recent orders of the court. The minister referred to the order on the provisional measures in the case of Nicaragua versus Germany. 15 judges, unanimous. It's very hard. I don't know if you've tried to get 15 people in a room and agree on what's going on in the Middle East. It's pretty challenging to do it wherever you are. And yet these judges seem to be not only to reach some kind of an agreement, but to do it with a great deal of unanimity. And as I say, states seem to trust it, and I suspect that they're going to do more of it in the future as well. So I am going to conclude with this. These are thoughts about the future of the Genocide Convention. I think it has a great future ahead of it, and it's going to play out in the next 2, 3, 4 years. This convention that I think many people thought even only 2 decades ago was dormant and was more of a historical curiosity than a living instrument. Thank you very much. Thank you.
So thank you so much, Bill, for this wonderful presentation and your compelling argument that the Genocide Convention has a sort of a monumental character, and other than crimes against humanity and war crimes has been left untouched in a way, and maybe there is room for development. Now, it's a good tradition to have a Q&A session, and I'm glad that you agreed to have this here tonight too. We have 2 microphones here, one on the right and one on the left. So if you have a question or want to raise your voice, have a comment, please feel free to stand up or raise your hand and then go to the microphone. There's a first question, and then there's a second question.
Professor Schabas, thank you for this very interesting lecture. My name is Gabriel Armas. I'm a human rights attorney from the US, currently a PhD candidate at the University of Groningen. My question is regarding the recent request by the prosecutor at the ICC regarding a number of crimes, and one of them being the crime of extermination. Now, my limited understanding is that the definition of crime of extermination is very similar to the Article 2C of the Genocide Convention. So it seems like the actus reus between extermination and genocide are quite similar, while the mens rea is different. 1, is my understanding correct? But 2, if so, do you see kind of a forming of new case law that will help color how genocide will be interpreted by this kind of new developments of crimes against humanity in the form of extermination?
Okay.
Very dogmatic question.
Yes, very technical, dogmatic question. Well, what you're referring to is the crime against humanity of extermination, which is in the Rome Statute, and which has often been viewed as being perhaps the category closest to genocide. The other category that, in crimes against humanity, that's closely related to genocide is persecution, because persecution refers to racial groups being targeted or peoples being targeted based on their identity, and that includes the 4 categories we have in the Genocide Convention. Extermination is a bit of it's not something that's been prosecuted a great deal, and the prosecutors obviously decided to emphasize this. It's very clear in the applications. I think it's too early to tell how that's going to result. That's all. There are some choices that he made and we saw this in the release yesterday and in the statement, and we'll see what will happen with the judges. As you know, the judges at the International Criminal Court also have the freedom to recharacterize acts. So we can't exclude the fact that they might at some point, we can speculate on why the prosecutor didn't charge the crime of genocide, because it's a central crime and there have been many allegations from various states in the charges against Netanyahu and Gallant. But whether that will emerge in the future is possible. Did he make just a strategic decision not to be more provocative than he had to be, although he obviously succeeded in kicking the hornet's nest, so to speak? I don't know. It's interesting to, people will write law review articles on this, but I don't have a lot of insight to shed on it. You referred also to paragraph C of the definition of genocide in the convention, which talks about imposing conditions of life calculated to destroy the group, and that would be also closely related to extermination as it's been understood. The idea of a slow death through various means rather than gas chambers or machetes, I suppose.
All right, thank you very much.
Rainer?
Yeah, thanks so much. As always, I've learned so much from your lecture, but I'm not entirely convinced in all the arguments about, coming back to the beginning, especially when you mentioned, with good reasons, the not so good reasons that the Allies had to exclude crimes committed by the Nazis in peace times before the commencement of the World War and the Holocaust from the concept of crimes against humanity. But what I didn't quite understand is why you accept Raphael Lemkin's thesis that the answer to that omission was the Genocide Convention and not what seems much more logical, a convention on crimes against humanity, which would have, in my opinion, spared us a lot of the problems now of distinction in the different courts to distinguish between what deserves the term of genocide if you belong to certain groups. If you don't belong, you don't deserve that highest rank of criminality, as many people think. So, I mean, this was possible at the time. It could have been done as easily as, or as difficultly as the Genocide Convention. And in fact, the International Law Commission made efforts, and I don't remember the year, but I think it was in the 1950s still, that the International Law Commission struck the connection between war times and crimes against humanity, but it never became a convention. So that's, and correct me if I understood you badly, that's the reason why before the ICJ, only genocide can be dealt with, because the ICJ does not have an equally strong legal basis to deal with crimes against humanity. Whereas in criminal law, it seems no problem at all. And in criminal law, anything that can fall under the Genocide Convention can as well be dealt with as a crime against humanity. So I always ask myself whether the human rights world would really be needed the Genocide Convention, or if our standing as human rights defenders would not be as equally good without the Genocide Convention.
So on the necessity of the Genocide Convention, and again the two concepts, crimes against humanity and genocide.
Dr. Dickert referred to Philippe Sands, who's of course a good friend of mine, and I saw a talk that Philippe gave only a few weeks ago somewhere, where he called into question the need for the Genocide Convention at all. Very radical suggestion, especially considering that he's a lawyer for the Gambia in the case against Myanmar. But I know his own views are really also very skeptical about the legal utility of it, when we should be putting our investment into crimes against humanity. Some of it also relates to these personalities that we all refer to. So Lemkin was an odd individual, if I may say so, and he had some very curious views. He hated the Nuremberg principles. He thought the Nuremberg principles were terrible. If he were alive today and you invited him to give the lecture, he'd probably refuse to come, He really thought they were a bad idea, and he thought they were a plot to undermine the Genocide Convention. He also hated the Universal Declaration of Human Rights. In fact, both Lauterpacht and Lemkin thought the Universal Declaration of Human Rights was a waste. They didn't like it at all. But on the question of whether the difficulty, the shortcoming of Nuremberg, the failure to deal with peacetime atrocities could have been addressed by reforming the notion of crimes against humanity, absolutely, it could have been. But I think for the reasons that I've said, it would be unlikely to succeed the way the Genocide Convention did because it's so much broader. That's the problem. And, you know, we still don't have a Convention on Crimes Against Humanity. There has been a proposal underway for that for now a good 15 years. It's something I was on the steering committee of that developed the draft Convention on Crimes Against Humanity. It's now been before the 6th Committee of the General Assembly for the last 5 years, and we can't get it to move forward. And that's just to get a text adopted. Don't even begin to think about getting it ratified by states. And I can just imagine if that convention is adopted, imagine that you're the legal advisor who has a nice idea that you're going to convince the minister to ratify the Convention on Crimes Against Humanity, and the minister will say, well, do you think that law we have would be against the Convention on Crimes Against Humanity? And the answer would be, I'm not really sure. So, well, I'm going to give you an example. It's widely agreed. So I referred to this mystery in my family tree that I don't entirely understand about the marriage of my great aunt and her husband. But we do know that for a period, the marriages between Jews and non-Jews were absolutely prohibited. And we've seen that in other countries. And those types of laws are alleged in the Myanmar proceedings and in the allegations against the Uyghur and so on. So it's also an act of, if you prevent marriages of people of different groups, this could be a crime against humanity. I don't think that's even a controversial idea. So suppose you come to your minister and say, and the minister says, so if it's a crime against humanity to prevent marriages between people of different ethnic groups, would it be a crime against humanity to prevent marriages between people of the same sex? And the lawyer would say, well, it's never been decided. And the minister would say, well, if it's never been decided and if you don't know the answer, then I'm not doing it. And that's the problem with crimes against humanity. It's very broad, potentially. It's very broad. And so that was even more so the situation in the 1940s. You know, you're right that in the International Law Commission, they did experiment with changing the definition from Nuremberg. So it was in 1954. They had a vote to remove the nexus with armed conflict. They actually took a decision. It's amazing to go and read. You can read the debates in the records of the International Law Commission. They had what I'd call like buyer's remorse. You know the expression, buyer's remorse, when you go and you buy something that looks pretty good, and then you go to sleep and you wake up in the middle of the night, you say, my God, I spent money on that stupid thing I have to get. You know, you agree, we've all been in this, we're in a meeting and we agree to do something, and then someone says, you know, there's something we just forgot about. And so they come back the next day and they say, we removed the connection with crimes against humanity and armed conflict, so now what's the difference between crimes against humanity and ordinary crimes? We have killing, we have torture, we have other acts that are in the definition of crimes against humanity, but if we've removed the connection with armed conflict, then there's no way we can distinguish between the crimes against humanity and ordinary crimes. So then they set up a little subcommission, and they came up with a proposal that added a connection of state policy to it, which is what we find in the Rome Statute. That's how we resolve this in the Rome Statute, is with an obligation of state policy in Article 7 2A of the Rome Statute. So the problem was there. You're right, they could have done it, but these were early days in terms of the codification of human rights and of international law, and that's why they didn't. So we have this strange international system that's developed from different sources. It's not a coherent system. Genocide Convention, grave breaches in the Geneva Conventions, customary law. It's not like a domestic legal system where we have a committee in the parliament that creates it. It comes from different directions, and it's not always coherent.
There's another question here.
First of all, dear Professor, thank you very much for your lecture. My name is Ksenia Smirnova from Taras Shevchenko National University of Kyiv from Ukraine. So thank you very much for this, our deep dive in that puzzles and that historical overview on all that issue. So my question maybe would rely maybe on some perspectives and your personal academic view on how it would be, because unfortunately we can see now, and we are gathering now in Ukraine, if I'm aware right, about the litigations, that under the internal legislation we are already gathering the information about genocide in Ukraine, especially with this motto on denazification and denationalization of Ukraine that we heard in the beginning of the full-scale invasion. And of course, gathering all the information and all the witnesses 10 years ago, that when the war started. Of course, there are a lot of difficulties, legal obstacles on ICJ jurisdiction, and I think there is no way out on the decisions made by ICJ in that case. There are some internal complicated issues with the International Criminal Court as well. Now Ukraine is dealing with a new tribunal, and with the creation of the tribunal ad hoc on war crimes. Of course, the aim of that is that leadership crimes, not the state crimes. Of course, I think that the primarily cases would be aggression and war crimes, and genocide as well. Just your personal assessment, how it could be in the perspectives on the creation of new ad hoc tribunal, and how these issues could be included there with witnesses, with evidences, and so on. Thanks.
Okay. Well, yeah, this could require a complicated answer, and really it needs a conference to address all of the issues. I mean, Ukraine is a sovereign state, and it's free to create new courts, and it's free to prosecute crimes as long as it doesn't violate Article 7 of the European Convention on Human Rights, which is the rule against retroactivity. Otherwise, it's a sovereign state, and it can do this. I've been myself engaged in various ways with the Ukrainian justice system in the last 2 years to help to build capacity. I don't know, it seems to me that the search for new institutions maybe is not all that useful. It's my own impression. I think that the domestic legal system, I mean, the volume could be huge, but we don't quite know exactly even what that will be because of the prisoner exchanges and everything, who's going to actually be there to be prosecuted. But the domestic legal system, with a little extra capacity, or a little or a lot, should be able to do this. I'm also just a wee bit suspicious of all of the, there are a lot of people from outside Ukraine who are looking for a job there, and they'll get involved with these different projects and make them more elaborate than they need to be, whereas what you really need is greater capacity within the Ukrainian system. It's also a system that, of course, is subject to the supervision by the European Court of Human Rights, which is a guarantee of its reliability and of its credibility. I know that there are the special cases, of course, of a tribunal for aggression. You didn't mention that, I don't think, but that's the one that's on the agenda. And it's clear there, although you do have a crime of aggression, I forget the name of it, in Article 4 something in the Ukrainian Penal Code, but certainly to prosecute at a certain level. And of course we have this strange rule with the crime of aggression that we can only prosecute the senior leaders, the people in a position to prosecute them. That comes from the Rome Statute. It comes allegedly from customary international law, so this is a complicated issue. It's well beyond the scope of my lecture tonight.
Thank you. Thanks.
Thank you so much. I have two more questions. Julia.
Thank you. Julia Klaus, Friedrich Alexander University, Erlangen, Nuremberg. Allow me a slightly heretical question as to whether the genocide definition as we have it right now might actually be doing, to some extent, more harm than good. Based on what Rainer Hule already said, I'm wondering whether that definition of groups in the special intent is actually fostering this toxic thinking in groups, that processes of othering are usually followed upon, and that are among those roots and causes of genocidal activity that Alice Nderitu, as she mentioned in her opening remarks, tries to fight by engaging in educational activities, etc. You know, if we take that definition, as you said, as historically conceived as part of international criminal law, these definitions of international criminal law are not, strictly international, but rather addressed to us as individuals and demand our loyalty to humanity, to mankind, as something beyond groups, beyond national, ethnical, racial, or religious groups. So I wonder whether you want to, stick to that part, to that group thinking so inherent to genocide in any future definition, however it may be changed, or whether you see any opportunity of overcoming that and, making sure that the definition actually does not somehow, in a subtle way, foster what it actually tries to prevent and punish.
It's an interesting reflection on the Genocide Convention. I think, and maybe this isn't a direct answer to your question or your idea, but it's I think in the same spirit or along the same lines, is to understand the Genocide Convention as being essentially a treaty or a convention dealing with racial discrimination. So it is about persecution and ultimately destruction. If we're in crimes against humanity, we don't have to have the destruction, but the persecution of people based upon their identity, using these terms that some of which are completely obsolete, like racial group is really an obsolete term, at least in terms of a scientific reality, but that we all understand what they mean nevertheless, and they're about something that we will call identity, ethnicity, whatever. And that was the driving force behind it. As was said earlier as well, the Genocide Convention is a reaction to the Shoah, to the Holocaust. And that's true, but to an extent, only to an extent, because I think it's broader than that. I think it was really a recognition following the Second World War that humanity had come to some terrible place where this sort of thing, Auschwitz and so on, could happen. And that this was not something that was just a perverse spark in the German character or the result of Nazi demagogues, but that it was something much more historic. Of course, different people came to the drafting and promoted the idea of the convention with different backgrounds and different ideas. But it was this idea that the notion of superiority of one group over another, which was the foundation of colonialism as well, and of the justification for the slavery and the slave trade. So we'd had centuries of it by 1946, and there we were with these camps and 6 million people who had been murdered for no reason other than their identity, and that this had to be addressed. But as I explained, the problem was that imposing law to deal with that remained difficult for many states. Eleanor Roosevelt, the great Eleanor Roosevelt would come to the United Nations. She would write in her diaries and in her letters to people saying, "It's hard here because they keep throwing at me what we're doing to the African Americans in the United States. She says, how can I stand up and tell other countries that these should be the standards they apply when we don't do it ourselves?" And there was one of the first charges of genocide under the convention was made in 1951 by an African American organization. They prepared a book called We Charge Genocide. If you don't know it, you can find it on the internet easily, a copy of the book. And they documented all of the persecution, the lynchings and murders and so on of African Americans, and they went to present it to the United Nations. And Eleanor Roosevelt said, "This is a distraction. Raphael Lemkin was dismissive. He said, "Oh, don't deal with this." They were, because they understood you could make some progress with the prohibition of genocide, but prohibiting racial discrimination was a much more daunting task, and that's what I don't know if that's what you're getting at, but this is my reflection on the convention, that it's part of a larger problem, and that was what was at its origin, was dealing with this idea of racial discrimination, which is the worst poison for humanity for many centuries, and we're still fighting with it.
Thank you.
Thank you so much. I would take a last question before we close for today.
Thank you so much. Thank you. Fantastic lecture. I'm Steve Crawshaw, formerly of Amnesty International Human Rights Watch, now writing a book on war crimes and justice. I've been in Israel and Ukraine recently. Following on a little bit from your previous question and answer, so the Genocide Convention is there, and for the very good reasons that you've also described. But in terms of the hierarchies, do you think that's challenging? If you look back, Cambodia, for example, which everybody conventionally describes as genocide, and the courts found it to be genocide, but only because of quite narrow slice, if I'm correct, which was the Vietnamese targeting, which was not what the main killing of most of the 2 million was about. And other places as well where you've seen things which are not ethnically driven. We're seeing a lot of competition both in Ukraine and also in Israel about people demanding that it be at this level rather than this level, and becomes almost a narrative that you are underplaying the crime if it's not described as genocide. Do you see that as difficult, or given, again, to take the Cambodia example, you can have an enormous, whichever way you describe it, both in Gaza and in Ukraine, huge numbers of civilians are being killed in ways that are very troubling. So crimes against humanity ticks that. So interested in your thoughts. Thanks.
Thank you, Steve. I didn't mention Cambodia. I could have added that. And of course, there was not an international tribunal for Cambodia, but there was a big international effort to set up what was called the extraordinary chambers in the courts of Cambodia. And they, of course, did develop, they had convictions, but only for the Vietnamese and for 2 minorities, and the Muslim Cham minority, and rejected. There was a dissenting judge, again, if you're compiling the evidence of the reformers, the ones who want to broaden out the definition of genocide, there's quite a powerful opinion by one of the judges on the court, but in a minority. And yeah, there's this idea that genocide, and it's something, and I focused, of course, on the law as well here. I could have talked about the more social dimension of the debates about genocide and the use of genocide and the term in a political context that's not really very strictly legal. 2 years ago, President Biden was asked, it was almost like an offhand comment, he was visiting a farm in Iowa, and the journalist said, "Do you think it's genocide in Ukraine?" And he said, "Yeah, I think so." Now, I think if you said to Biden, "So which paragraph of Article 2 of the Genocide Convention are you talking about?" he would say, "I'm afraid I don't know anything about that. You'll have to talk to the lawyers." But it gets used by politicians. The Russians did the same thing. The term gets greatly used in a political sense, and often in a quite a demagogic sense, and not where there's an indifference to distinctions, and it's just used because it appears to be something that can fan the flames a little bit. And we did that in Rwanda in 1993. We fanned the flames a little bit. People do it, activists do it to direct attention to an issue. And victim groups also view it as being a kind of a badge of honor, so that if their victimization is not characterized as genocide, they're kind of in a second-rate category because they're not victims of genocide, and it becomes extremely important to them in that context as well, and very difficult to sit down and talk reasonably about it. I've learned the hard way with Armenian friends of mine, trying to say, maybe there's a way forward in the quarrel you have with Turkey. Maybe we could agree to call what happened in 1915 crimes against humanity, take the sting out of the word genocide, and some of them agree, and some Turks agree too, but some Armenians say, that would be a dishonor, that would be denying the truth and the reality, and some of the Turks say, we'll never agree to anything because we were innocent, the Armenians deserved it. These are not simple things, but in trying, and I know that it says in the brochure that the theme of these lectures includes an element of transitional justice, although I didn't speak about that much. But if you're talking about transitional justice, you're also concerned with getting people who've been in conflict and at war to get closer, to learn to live together, and that's part of it. And the word genocide isn't always helpful in doing that. It's not always going to be the way that you're going to get people to reconcile. Sometimes you have to temper the language a little bit, and that becomes difficult as well. But that's a whole other dimension of the issue of genocide, is this mystery, this about the word, the enigma of the word genocide, outside of these treaties and judgments and provisional orders and applications and all the stuff that we international lawyers love to talk about.
Well, thank you so much again, Bill, for this wonderful presentation, first of all, and then for answering these hard questions, some of them very technical, some of them very political. It's really an interesting topic. And genocide is such a strong term, as you just elaborated, that it's so attractive to be used. And it's a reality. I mean, we can talk about abolishing it, but it's there. It's politically there. And this is also why I very much appreciate your presentation, and I appreciate the development before the ICJ, because it's used as a legal term, and it's been fought about in a court of justice. So we will see what the outcome will be and where it develops. International criminal law is obviously very diverse. We have conventional law, we have customary law, we have the Rome Statute, all these different sources. We have to deal with them as international lawyers. And I'm very, very grateful for you enlightening us about, in particular, the ICJ, and it's moving forward in defining further the crime of genocide and its implications about the responsibility of states and individuals. So thank you very much, William Schabas, for coming to Nuremberg and giving this wonderful lecture tonight here in Courtroom 600.
Thank you very much. Thank you.